Good afternoon, everyone. As you may know, my name is Jessica Tercy, and I'm the Director of Disability Services for Goodwill Industries of Southwest Florida. I am joined today, obviously, with our great friend, Blake Hampton, who will be sharing some very important information. I do have some housekeeping items to keep in mind, please. I do ask that everyone remain muted during the presentation. If you have questions, please put them in the chat. I will be reading them to Blake here at the end of the presentation. And obviously, if you would like more information on future sessions, please put your email address in the chat option as well, and I will be taking those down. And without further ado, I will be passing along to Blake.
All right, good. I'm not muted. I always have to check and see if I'm muted or not. Thank you everyone for attending this presentation today. My name is Blake Hampton. I am an elder law and special needs planning attorney, so I deal with wills, trusts. I help people plan as they age, and then I also help individuals who have different special needs, whether it be developmental disabilities or sometimes it's injuries from other auto accidents and things like that as well. So that's my bio. Jessica, you didn't see this, correct?
Yes.
Okay, just making sure. This is like my second or third time doing a PowerPoint via Zoom, so I'm a little new. I'll apologize now. All right, so today we're going to talk about planning for the future, and that is planning for the future with if you're an adult with a special needs child. This is really a presentation that's geared towards you. So big first step is when you have an adult, a special needs child and they're minor. It's like my brother. He had everything taken care of. He was in school. He had Medicaid, but he didn't have. He wasn't eligible for SSI. So when he turned 18, he's now legally an adult. So your child can make decisions for him or herself, even if they really can't. The law presumes that they can. Individual special needs can stay in school until 22. I don't know if that law has changed. I think it's 22 still. I know my brother was in school until he was 22. Very grateful for that. And then it becomes challenging from there. What happens after they can no longer stay in school? That is always a challenge. So they also might be at turning 18. Your loved one might be eligible for SSI or Medicaid. And the parent technically and legally can no longer sign on behalf of their child. Although I know how we operated, we would still have Grant sign his name, and probably not the best idea. But I'm sure a lot of parents have figured out their own workaround. We all just do the best we can. So this is a little matrix I made that just goes over the different topics that I'm going to be talking about today: estate planning, decision making, public benefits, and not really going to talk about financial planning at all too much, but we'll touch the surface of it. So estate planning. I don't know if anybody's ever had a will done or a power of attorney, but a standard estate plan deals with a last will and testament. It's a document that's made for the courts that tells the court and the public where you want your assets to go when you pass away. A revocable trust, and I'll explain what trusts are in a few slides. Actually, the next slide. Healthcare surrogate and power of attorney are both decision-making documents. So you're still alive and you've delegated your authority for decision-making to someone else. And a living will, that is an end-of-life document. So when two physicians certify that you are terminal and you are not going, highly likely that you are not going to quote pull through. The living will is the document that says that you no longer want to receive life prolonging measures. You're just looking for comfort at that point. And pre-need guardian or pre-need guardian for a minor. So you're telling the court who you would want to serve as your guardian, and there's also pre-need guardian for a minor. Means that you're telling a court who you would want to serve for if you have a minor child. And I'll get into what a guardian is in another slide as well. Healthcare surrogate for a minor. Again, you could, so if you have a minor child with special needs, you could absolutely use the pre-need guardian or the healthcare surrogate forms for minor children, and that can be very helpful. Supplemental needs trust. Some people call it a special needs trust. I'll get into the difference between the two in a few slides. And this isn't really a legal document, but it's a document. You can find it on the ARC's website. I have a few other links on how to draft a parental letter of intent. What you're doing in a parental letter of intent when you have a special needs child is explaining, take yourself out of life, and what is the daily routine of your children or your special needs child, and how do we maintain that routine? What medications they take, what they like, what they don't like, what they want to do every Wednesday or every Monday at 11. Because I don't know about you guys, but I know my brother likes his routines, and if we're off by even 15 minutes, sometimes it's not good. So children's estate planning or child's estate planning, not a minor child, but a special needs child could also have a last will if they understand, if they have assets. There are some adults, special needs adults do work, carry jobs, save money. So last will, power of attorney, healthcare surrogate, living will. But if, say, they are high functioning, they could have all these documents and then have what's called a support decision-making agreement. And that is a kind of a new area where we're trying to avoid guardianship and court involvement, and work with the adult special needs child and creating a agreement where they need support. So it's a lot less restrictive than a full-blown guardianship. So I'm going to get into what is a trust, because I talked about a trust twice already. Take a little sip of water. All right. So a trust is it's a separate entity from you. It is similar to a business, but not quite. It has a CEO instead of a CEO like a business has, or a director. We have a trustee. It's a separate entity from the person. Accounts are titled in the name of the trust. So instead of a checking account having your name on it, it would have the name of the trust, and it would list who the trustee or who is in charge of that account. Let's see. So beneficiaries, and unlike a business where a business has a business purpose and that's making money, the trust has a beneficiary. So these are all important components to a supplemental or a special needs trust. And I'm going to get into the difference between the two. Living trust, or inter vivos, or testamentary, meaning a trust that's created upon your death. There's very important distinction between the two, and in this type of planning, how you plan can make a big difference. So the two types, the two primary types, that is. So first party, we're not going to talk much about a first party. That is a true special needs trust, where it's created for an individual. It's created by the individual who has special needs, or his or her parent, or legal guardian, or by court approval. It's authorized by the Social Security Administration. This is what some people call a D4A trust, or self-settled trust. Must be irrevocable. It uses your child's Social Security number to open on any bank account. So it doesn't have its own tax filing. But there's a payback provision to the state. So when someone passes away and they've been on Medicaid, there's a Medicaid lien. And this type of trust has to report to the Medicaid Estate Recovery Department in Florida upon the death of the beneficiary. And the state gets paid back what the state files on its lien. So these trusts are usually utilized in the personal injury settlements, or sometimes in unexpected inheritance situations where a long lost uncle left your child money and they did not understand that your child has special needs. Sometimes we can work around that in court or outside of court and not have that be an issue. Third party. So third party means a trust created by someone other than the special needs individual or the beneficiary. So this is, for example, this is what a supplemental needs trust is instead of a special needs. So special needs, according to the Social Security Administration and the state, that is a key word that means payback provision. Well, when you're leaving money to a child in your estate plan, we don't have a payback provision. We don't want the state to think there's a payback provision. We use the word supplemental needs. So this type of trust is created by a parent or someone other than the beneficiary. It could be an uncle. If you say there's a wealthy, long lost uncle out there, he or she could be the one that creates the trust. It can be revocable, so you could create it now, and then upon a certain event like receiving money or your demise, the trust would then trigger and become irrevocable. The reason we may want a revocable trust until the trust receives money is we don't know what life holds, and changes happen. So we can amend that trust up until the point of your death or upon it receiving money. Upon your death, or whoever created the trust, or whenever this trust triggers and becomes irrevocable, it has a separate tax ID for any accounts that are owned by the trust. Again, very important distinction. Probably one of the most important ones between the two trusts is no payback provision. So you don't want to pursue a first party special needs trust in your standard estate plan. Those are very niche situational type of devices or agreements. Again, utilizing proactive estate planning and independence planning. So leaving money to this trust and possibly creating a team around your beneficiary, your child, or your loved one, and with the goal of trying to help them achieve the maximum amount of independence they possibly can and quality of life. So supplemental needs trust, typically created by parents. Parent typically is the trustee as long as they're alive, but trustee selection is a very important topic. I'm not covering it in this presentation, but I could honestly go on for 3 or 4 hours on how to create a team around your child. The child is a beneficiary. In this type of trust, you could, if you had 2 children, both with special needs, they could both potentially be beneficiaries of a trust like this. So the sole benefit rule of the special needs trust is not in effect. Child cannot be trustee. You can't have your cake and eat it too. That's really the big takeaway with anything in the public benefits realm, Medicaid, asset protection. You can't have control and complete access to money and also simultaneously say that it's not yours and I want Medicaid or a particular benefit. So there are certain restrictions on the ability of the trustee to distribute funds. They're generally restricted to supplemental needs, and I'm not going to get into the laundry list of what those could be, but the word supplement means or supplemental in this case, the trust is supposed to supplement what an individual is receiving from the government and not supplant. So we aren't supposed to pay for duplicative services. If Medicaid is paying for a particular service, we don't want the trust to also pay for that same service. It could jeopardize Medicaid. The trust also cannot make distributions back to your child. So if you put $1,000 in there, you shouldn't be distributing that $1,000 then to your child's individual bank account. And upon the child's death, the remainder of this type of trust could be distributed according to the rest of your estate plan. So if special needs child has siblings, the remaining trust assets, or what we call trust principal, could be distributed according to your estate plan, or we could build in estate planning provisions into the trust itself. And again, if you have questions, just send them in the chat, and I'll. I see. There's probably a lot of questions, so I will. I'm excited. I love questions. Benefits of supplemental needs trust: flexibility. So we can, even if it's irrevocable, there are ways to amend or change the trust. I'm not going to get into those in this particular presentation, but no trust is truly irrevocable. The trust could be revocable or amendable until it receives money or upon death of the parent, and receives funds from really either parent. So say you have a separate, you're divorced and you have a special needs child, you could create the trust, and ex-spouse could absolutely leave funds and name that same trust as a beneficiary. So you can still have a plan that really works in the best interest of your child. The entire estate plan, the benefit of a separate supplemental needs trust, creating it separate from your will, is the entire estate plan doesn't have to be amended or changed if you have changes to make to the trust. So if your special needs child is a 1/3 beneficiary of your estate, but you need to make changes to the special needs trust, if that trust is built into all of your estate planning documents, you have to change all of them versus just amending this trust. So it's a little more work up front, but the idea is that it's less work and more streamlined in the future. All right. So what does a SNT being supplemental needs trust or special needs trust typically own? It could own real estate. You could leave a house in the trust, or the trust could purchase a house or residence for the beneficiary. Vehicle. If there's a vehicle that's required for transportation, that doesn't mean your adult special needs child has to have a driver's license or drive, but the trust could own a vehicle. Could be complicated these days with auto insurance and just the amount of hurricanes we've had. Home and auto insurance have definitely become complicated estate plans. Investment accounts. That's probably one of the bigger ones that goes in that is titled into the name of a special needs trust. So if you have like an Edward Jones account or a Wells Fargo Advisors or wherever, Fidelity, Schwab, those accounts, instead of saying your name on it, would say the name of the trust. Now, you don't want to put retirement accounts. Retirement accounts can't go in these types of trusts. Retirement accounts can only be owned by one individual. Cash, so like liquid deposits. And I bolded life insurance because if you're a working person and you don't have tons of money, but you're insurable, life insurance is one of the best types of assets to leave. You can have the trust actually own the policy on your life, and then when you pass away, the trust receives the life insurance proceeds, tax-free as well. So that's my big pitch for. I don't sell life insurance, but I'm a big believer in life insurance and its benefit in this type of planning for sure. So other than supplemental needs trust and special needs trust, one of the other ways that individuals with special needs can be protected, have resources, and still qualify for Medicaid and or SSI is what are called ABLE accounts. And our local or our state ABLE organization is ABLE United. I can put some of that, I can send Jessica some of that information, the handouts, like the ones I had in my last live presentation, and she can circulate them if anybody wants them, or you can always email my office. So if you have a 529 account or ever had one or familiar with one, this is 529 capital A. It was authorized by the Internal Revenue Code. Let's see. So you can deposit up to $17,000 per year. Anyone could contribute to that account. So if you open it, again, your brother could make a deposit for his special needs nephew, your son, or what have you. There's no restriction on who can make the contribution. Not a resource until for Medicaid purposes or SSI purposes until the account balance is over 100,000, and then you start to see a reduction in benefits. And it can pay for what are called qualified expenses. And Able United's website's fantastic. They have a lot of educational material. I'm a visual learner, and they have little boxes for the different types of qualified expenses that a Able account can pay for. So again, this type of account can be established by the individual, or by power of attorney, or by a legal guardian. So you as a parent don't have authority alone to sign up and create this type of account. Either your child needs to sign the paperwork, they need to have signed a power of attorney to you that allows you to open this type of account, or you have to be the legal guardian, or in Florida we call it guardian advocacy, or a guardian advocate. And I'm going to get into what that is in a few slides. This type of account has no payback provision at the moment. That's been resolved, I believe, by federal law, at least by federal administrative rules. So that could always change in the future, but at the moment, there is no payback provision upon the death of a beneficiary, and my sources tell me that's not going to change at the moment. So I always keep my fingers crossed, though. Supported decision-making. So now we're transitioning away from trust and estate planning and into your special needs loved ones decision-making. Supported decision-making is an alternative to guardianship. It's very new. There are some good websites on supported decision-making. Florida has not taken up the mantle as well as some other states have, surprise, surprise, but there is a very useful website on supported decision-making in Florida. And yep, turning18.org. That's the website. And all the resources we'll go back over at the end. So guardian advocacy is the more restrictive approach to, instead of a power of attorney and supported decision-making, guardian advocacy is an abbreviated guardianship process. So that's a court-driven process where you petition. A petition is like a request to the court to be appointed guardian of your special needs child. If they were developmentally disabled before the age of 26, then usually like an IEP an old IEP is good evidence that your child was developmentally disabled before the age of 26. So that's part of the requirements of guardian advocacy. This is a much more abbreviated process than a standard guardianship. So the court appoints an attorney once you file the petition. Usually the same court-appointed attorney that's been around for a long time. He also has a special needs brother, so he is very familiar with the process. Court hearing. Once the court-appointed attorney is once an attorney is appointed by the court schedules a hearing, and that hearing is on the appointment of guardian. Once the guardian is appointed, you have what are called letters of guardian advocacy that are issued. Well, we're not done yet. That's the problem. Now we have to file an initial plan. You know, what is your child's daily routines, medications? What do they do for fun? The court wants to know that you're trying to maintain the child's quality of life. So they're really up in your business at this point, but it's somewhat of a necessary evil. Inventory. That's what does the child own at the time of the letters of guardian advocacy are signed by the judge. So that is your snapshot date. So if they only have $700 in one bank account, that's your inventory for the guardianship. Every year, there's an annual plan and annual accounting that must be filed. If your child only receives Social Security and no other assets, sometimes we can get the court to agree to simplified accountings, and yeah, I think that's simplified accounting. If you're appointed a representative payee by the Social Security Administration. So beyond annual plans, guardianship it goes on in perpetuity until the death of your child or the restoration of their rights. So some individuals are, again, they may mature, they may take longer to mature, but in their 40s, they are able to make decisions for themselves, and that can lead to restoration of rights. Public benefits. So we're moving out of the decision-making realm and now into the how do we pay for care? How do we pay for life? So SSI is a means-tested program administered by the Social Security Administration, so it's a federal benefit. SSDI is not a means-tested benefit, meaning it does not involve income or assets. It's all about whether you can work or not. And then another one of the important public benefits, Medicaid. There are multiple flavors of Medicaid. I will get into that on another slide. Oh, actually, it's this slide. Developmental disabilities waiver, or iBudget. So if any of you have dealt with APD, Agency for Persons with Disabilities, they're the kind of the overlord, if you will, of the iBudget waiver. And iBudget stands for individual budgeting. Here's another one of those government terms that's a mouthful. This is the long-term care Medicaid or state-wide Medicaid managed care long-term care program. That is a program that typically pays for home health care, assisted living. There is a version of a Medicaid managed care waiver for developmental disabilities, but I believe they're trying to merge the two more and more. I see APD losing more and more control over their end of the spectrum, and it being transitioned to the Agency for Healthcare Administration, or ACA. The next type of Medicaid is community Medicaid. That doesn't pay for long-term care, doesn't pay for job training, doesn't pay for occupational therapy. Just it pays for your basic medical bills. Medicare. The difference between Medicare and Medicaid is that Medicaid is a federally and state-funded, state-administered program where the feds give the state some guidelines that they have to play within, and the state tries not to follow them. I mean, to follow them. And then Medicare is a federal health insurance program, primarily for individuals, I believe, 65 and up. And then if you have been deemed disabled on SSDI for 2 years or more, you are eligible for Medicare. So SSI rules. Maximum amount of, oh, I had two slides tagged together to fade in, or 2 points. Maximum amount, not a lot of maximum amount of income, or no, I'm sorry, this is the maximum payment. $914 is the maximum possible payment. But a lot of folks, especially if you have a child that lives at home with you, you're probably not receiving that amount, because there's what's called an ISM reduction, in-kind support and maintenance. So if you're not charging them rent and they're not sharing in the overall cost of living, and it's not being reported properly, there is what's called an ISM reduction. It's there's I think a $20 disregard, and then it really can reduce I think up to 1/3 of the benefit can be reduced. I'm not going to get into what type of state Florida is. Florida is there are two different types of states, primarily in the way they administer the Social Security rules. And I meant to edit that out of the slide. That's a rabbit hole. $2,000 is the countable asset limit. So there are certain assets that Social Security Administration counts, and there are certain ones that do not count against that limit. And there is a 36-month look-back period on impermissible transfers. Again, these rules are very similar to the rules for a nursing home Medicaid or the home or community-based services Medicaid. SSDI for your child. So if you retire, we found this out personally. When an adult parent retires, if the child is a dependent at the time the adult retires, they may be eligible for the disabled adult child type of Social Security disability. This is it could potentially be a big bump in benefit to your child. So they're not receiving $600 or $500 anymore from SSI. Now they're all of a sudden receiving like $1,500 to $2,000, and it's not even it's all related to work. It's not related to your money or to your child's money. It all has to do with you retiring. So the child has to be dependent of that retired person, a retired parent, and the SSI then converts to SSDI. And that can cause all sorts of other potential problems. But one thing that Medicaid already understood when they created this disabled adult child benefit was that that any type of Medicaid that you have converts to a protected form of Medicaid, meaning you don't lose your Medicaid. So if a child has the regular community Medicaid and they now all of a sudden are receiving $1,500 a month, they will still, or say they're receiving even $2,300 or $2,400, even though they're receiving too much money for that type of Medicaid, their Medicaid is protected. And so these were the different types that I've discussed earlier. Community Medicaid, HCBS waiver, that's home and community-based services waiver. So 18 or older if they're disabled, 65 and older. Again, this can help pay for assisted living. This is important. This can be an important benefit as your child ages. This benefit is operated slightly different than the developmental disabilities waiver. They also must have medical eligibility level of care. So if they have their own job and they take care of themselves, they may not be an ideal candidate, which is a good thing. This type of Medicaid, just like nursing home Medicaid, has income and asset requirements. So you can only make so much money and you can only have so much money. But there are certain assets that Medicaid does not count, like your home, vehicles, IRAs, 401ks. Again, there are some exceptions to these different rules. Sometimes a Roth IRA could count for Medicaid, but I'm not going to get into the tangent there. iBudget, developmental disabilities, individual budgeting waiver. That's the full mouthful term for iBudget. All right. So I tried to get through that somewhat fast. I skipped a few points, but your resources out there, your financial advisor, always a good resource. The clerk of courts, they have handouts on the guardian advocacy. So they have like the forms themselves and self-help. The guardian advocacy process does not require an attorney. So you don't need me or any attorney to guide you through that process. You can actually go to the clerk of courts and download the resources or ask them for assistance. They have really beefed up that self-help area. Able United, fantastic website. Again, I have a handout with all the links. I'll send that handout to Jessica so she can circulate it. The Academy of Special Needs Planners, that's a great resource page with a lot of articles on tons of topics regarding your estate planning and planning with a child with special needs. APD, Agency for Persons with Disabilities. Their website needs a little bit of an upgrade, but it is a good resource and it's a great place to start if you are looking for Medicaid or assistance for your child. And then nonprofits, I'd say that one for last, like Pathways Goodwill, LARC, which I serve on the board of. Let's see, but there's Family Initiative, that's another one. There's a bunch of them though, and it's good to, and they all, there's some overlap with the nonprofits, but they do serve different purposes. So it's, some focus on minor children, some focus on adult children, some focus on work, just depends. So let's see. Oh, that's it. Let's stay right there. All right.
All right, Blake, looks like we have two questions. The
Okay.
first one is, who must be noticed / served with a petition for the hearing for guardian advocate petition?
Oh, wonderful. I love that question. So that should I stop my screen share? Is that going to be easier to get the PowerPoint slide down now? Or
yeah, you can stop sharing.
all right, perfect. All right. So who must be noticed with the petition? So next of kin. So if you're a parent and you're filing, then the other parent would need to be noticed. So that's yeah, depending on the situation, there's not really a way around that. But if say you're a brother or a sibling and you're filing that petition and both parents are still alive, they are next of kin and they have to be noticed.
And the next question is, does SSI automatically convert to SSDI, or do the families have to apply for SSDI when parents retire?
From my experience, personal experience, the SSI converts to SSDI. If it doesn't, it's not a bad idea to check with the Social Security office when you're retiring and claiming Social Security to see if your child is eligible for that disabled adult child benefit.
And one more question just came in. Is there an age limit as to when a disabled adult child applies for SSI or SSDI?
Is there an age limit? Well, no, yes and no. It's almost, I wouldn't say impossible, but the way the rules are written, it's unlikely that somebody under the age of 18 is going to receive SSI. Once they're an adult, over 18, that's when age-wise they'd be eligible for SSI. The disabled adult child benefit is really dependent on the retirement of the parent. So if the parent lives, if the child lives with the parent and the parent retires and the child's been on SSI, then and they've been developmentally disabled before the age of 26, I believe. They don't quote me on that one. This doesn't come up very often. It's really rare, but it's useful to know because we ran into it ourselves. My own family ran into this particular issue. So yeah, there's not like an age limit per se. I think it's more driven on retirement.
And two questions just came in, Blake.
I can circulate those rules too, by the way.
Yes. Do supplemental needs trusts transfer from state to state?
That's always a good question because Florida is a very like transplant state. You know, you shake up the country and everybody seems to trickle down to Florida. I always recommend getting your documents reviewed by, so if you're moving from here to Maine, I always recommend it's best practice to get your documents reviewed by an attorney in that state to make sure they're compliant. There are a few states such as Massachusetts, and I can't remember if there's any more, that are very strict on certain types of these asset protection type trusts. So yeah, that's the document still could be good. I've seen on my estate administration experience when somebody passes away, I definitely have had children come to me. Oh, his mom's will's from Indiana. Is that going to be okay for probate? She died a Florida resident. She died in Lee County. Yeah, absolutely. If it meets the requirements of Indiana at the time, again, there's some additional rules, but just because you move states doesn't mean your documents are all bad. I think that's just a little too simple.
Another question is, does it make a difference if the guardian petition is filed before or after the child turns 18?
You can, I believe you can do it at 17, and they were changing this law, and I don't know if it passed. I had some friends that were in Tallahassee and part of these proposed bills. I'm glad you mentioned that because I'm going to look them up after we're done. Right now it's 18, but I know that there was a bill that was proposed to allow at like 17 and a half to I believe get that process proactively going. It doesn't take very long. It's a very abbreviated process compared to a normal guardianship.
And someone put a scenario in here. It says, if I made an account, can I put his work money into this account and it won't be touched?
I need a little more clarification, and like an account for nobody's gonna come in and take the money per se. It's if you have money in an account and you apply for Medicaid, or you're already on Medicaid, and it's in, your work money should go in your account. And SSI and Medicaid, I believe, both have the ability for income verification match. And I just don't see any way around. Oh, special needs account. So yeah, that's always an interesting topic. I really think if somebody is working, they should be working and spending that money monthly. That you really don't want to be as a special needs adult saving your work money. I know it sounds kind of bad, but money accumulating in an account is not good. And you could shift it into an ABLE account, but it's not going to matter from a reduction standpoint. So yes, you could make work contributions to an ABLE account, but your paychecks should go in your account first and foremost before they go anywhere else.
Okay. And unless anyone else has a question, it looks like that is all the questions we have for today.
All right. Well, thank you very much, Jessica. Thank you, Goodwill, for having me, and thank you all for attending. And if you have more questions, you can fire them to Jessica. I signed her up for that, or
yes.
Or you can fire them to my office at info at Hampton. That's HAMPTON.LAW.
Yes, I will send emails out to everyone who put their emails in the chat. Thank you so much, Blake, for all this information. And definitely, if you think of any other questions, feel free to reach out. I will actually put my email address in the chat really quick in case anyone wants to reach out to me.
Maybe I'll do the same. Let's see. Perfect.
All right, and
awesome.
I think we all just put our emails in there. So take a minute to take our email accounts in there. And then we will go from there. But thank you so much, everyone. And we look forward to seeing you at possible next sessions.
Take care.